So I want to talk about some of the legal cases that I've learned about. Some I've been involved with peripherally, and I have to say I'm not a lawyer. I've just been helping as an activist. And there's a lot of legal issues I don't understand, but I do understand that we need to fight legal cases either because we have to, in the case people are charged with crimes, or because we want redress. I've divided them into 4 categories: adult sexual cases, other adult cases, maternal cases, and I agree that mothers are generally adults too, but I didn't know how to categorize it better, and the fighting back, which is when we go after them. So some of the adult sexual cases and some of the highlights of those cases, you may have heard of Newshawn Williams. That was one of the first big cases where a man was sent to jail. Well, the information I had was 4 to 12 years, but recently I learned that Newshawn Williams is still in jail, expecting to come out soon, although he doesn't really want to come out because his entire adult life pretty much has been in jail, and of course these days there's no training in jail, so he feels, what am I going to do on the street? He was supposed to have infected about half a dozen women, which is a statistical impossibility according to data from people like Nancy Padian, but that didn't stop the court. This case also involved what's often called, well, what is called phylogenetic evidence. If you've ever seen those sort of tree or web-like diagrams that supposedly shows the evolutionary tree of the virus in the alleged criminal, Newshawn Williams and his alleged victims, those phylogenetic diagrams are very important, and it was used in his case and published in a scientific paper. And they're very convincing for a jury. If a jury sees, here's his virus and here's the 6 women and here's everybody else's over here, they sort of get the picture, he did it. So it's a slam dunk. Another case I was involved with for quite a long time was the Andrew Chad Perenzi case in Australia around 2006 and 2007. In this case, we were lucky because we had a lawyer who got it. He didn't get it until Andrew Chad Perenzi had actually been convicted, but before sentencing. And so normally the time between conviction and sentencing is relatively short, but in this case it went on for a couple of years because there were all these fights over new evidence and the right to have an appeal. And some of the issues in that case were the status of expert witnesses. The Perth group were expert witnesses. The courts decided predictably that they did not have elevated enough status. If they had been virologists, if they had had a PhD, it might have been different. But the courts were able to dismiss them because they didn't have the right status. Courts don't care what you know. They care about your degrees, your positions, things like that. Also, the court case was an experiment because it had a singular focus on the existence of HIV, not on transmission, not on the dangers of the drugs and other things like that. And the case unfortunately failed, and Perenzi was sent to jail for many years. Another aspect that occurred after was that there was talk about having an appeal. There was another level of appeal, and Perenzi declined to appeal because he'd basically been told in jail that if you're not a well-behaved prisoner, then you won't get parole. And if you are appealing, you're not a well-behaved prisoner. Now, they're not supposed to say that, but they intimidated him to the point that he said, I'm not going to appeal. A precedent-setting case in Canada this year was of Johnson Aziga. I believe he's a Ugandan man, immigrated to Canada many years ago. He was accused, this might be the first time, he was convicted of 2 counts of first-degree murder. And I'll explain how first-degree murder works in Canada related to HIV. So usually these cases occur when people have consensual sex. Canada uses the law of fraud, and they say if you did not reveal that you were HIV positive to your partner, that is fraud, and consent is erased. So in other words, sex is no longer consensual, and sex that is not consensual is rape or sexual assault. Now, if you assault somebody with a weapon, that's aggravated sexual assault. HIV is a deadly weapon. Therefore, automatically, it's aggravated sexual assault. Well, what if one of these women becomes HIV positive, goes on the drugs, 2 women, gets non-Hodgkin's lymphoma, which is an acknowledged side effect of AZT. I think about after 3 years, 50% of people on high-dose AZT had non-Hodgkin's lymphoma. And what if these 2 women die of non-Hodgkin's lymphoma? A death that occurs during aggravated sexual assault in Canada is automatic first-degree murder with no evidence of intent. So Johnson Aziga was convicted of 2 counts of first-degree murder in Canada. Now he was part of his own problem because we, myself and Stephen Davis, who some of you know because of the 2 books he's written, went to visit the lawyers for Johnson Aziga in 2007. We spent a day with the lawyers. The lawyers got it. They totally understood what we were talking about. We were really excited about this. All they needed to do was to go visit Johnson Aziga in jail, which they did the next day, and he fired his lawyers. So and there was another attempt to contact his lawyers, but Johnson Aziga, I think, had gone pretty much insane in jail. He just was unable to function rationally. It was quite sad. Another case, I recently received a phone call from Carl Leone. He's a businessman in Windsor, Canada, who's serving 18 years. He was actually sentenced to 21 because he served 3 years house arrest before he was convicted. There were 15 charges. Again, he had consensual sex with these 15 women. He had kind of he went off the rails as a teenager, did a lot of drugs and sex, and because he was HIV positive, it caught up to him, unfortunately. I also spent time with this lawyer. I spent a week with the lawyer and the family, and the lawyer seemed quite interested but quite disturbed by the information that I was giving him. The day after I left, Carl phoned me up and said, I think I should plead guilty, which shocked me, and I think he was under pressure from the lawyer who felt this could blow up in my face, this could be the end of my career. If I take this on and lose, he was a big lawyer in a small city, and so he relied on all the doctors to help him out with the cases. He knew everybody, and so if he felt he was going to besmirch his own reputation, he was not going to take that risk. They almost had Carl Leone as what they call a sexual offender status, which would mean that he would never actually fully get out of jail. He could get out, but he would be on parole for the rest of his life. An interesting thing about Carl Leone is as a child, he had cancer and underwent massive amounts of chemotherapy and radiation to the point that he's actually sterile and not impotent, obviously. But he is sterile, and his growth stopped, and that's not uncommon with childhood cancer. So he's very small, a slight man, and that may be why he had a positive HIV test, because of the blood transfusions he received, because of the radiation, other things like that. But that was not brought up in the trial at all, because of the lawyer's refusal to deal with those issues. Another case in Canada was Charles Mazite, who was a Zimbabwean drummer and musician. Myself and Dr. John Hardy, who unfortunately can't be here this week, and a friend spent a day with the lawyer in Victoria. The lawyer, again, got it, was asking really good questions. You could tell from the questions it was really good. It was talking about using Rodney Richards as a witness. But then he said, well, I've got this foolproof defense. Charles Mazite did not know that he was HIV positive on the dates that he had sex with these women. Well, the foolproof defense gave Charles Mazite almost 10 years in jail. And when he gets out of jail, he's going to be deported to Zimbabwe, which is not a nice place to be deported to, especially when you've been away. Now, he was HIV positive probably since at least 1996. So here we've got 13 years later, he's a dancer. He's not dying of AIDS. It's like, how much more healthy can you be? This was his career was being healthy. And yet the courts had no trouble seeing this man as with a deathly illness. It's totally crazy. Another Canadian, and of course I know more about these Canadian cases, a Canadian football player. We have a strange system in Canada. We have the Canadian Football League, and 90% of the players are Americans. They can't make it in the American Football League, they come to Canada. So we have this American, Travis Smith, in the Canadian Football League, and there were 2 complaints against him. He was HIV positive, and again, he's a football player. It's like, you know, people say, well, he might look healthy, but it's like football players are more than just he looks healthy. They are healthy. Well, maybe they've got some knee problems and stuff. So he was convicted of 5.5 years in 2007. And in this case, I think Travis was the problem. Harvey Biley talked to him. I talked to him. Several people talked to him. There's a coach in Alabama who's interested in this issue. He appears in a video. I can't remember his name, unfortunately. He talked to him, but Travis Smith said, I'm just going to follow my lawyer's advice. Not always a good plan. Depends on your lawyer. Let's move to the United States. A soldier, Johnny Lamar, recently received 25 to 40 months for assault with a deadly weapon, HIV being the deadly weapon. There's another case that's been getting a lot of press recently, which is Philippe Padu, who's a gym instructor. Again, he's a gym instructor. I mean, I think he's relatively healthy. And so 6 women put complaints against him. They've been on television. Philippe Padu is basically being crucified on daytime television. And I don't know if he's been convicted yet. We haven't been able to contact his lawyers or anything. Yes, Clark.
He was convicted over the summer. I've been in contact with his wife. And he doesn't yet buy into the myth of HIV. He thinks he's HIV positive, and according to her, he's taking the HIV drugs. So I've talked to David Steele about it, and we think right now he's a lost cause, but in the future we'll try and pick it up.
Yeah, it's one of the messages that I have is that in order to win a case, you need the client, the accused person, to understand. They have to be able to do the right things. They have to be able to say the right things. They have to understand the myth, and the lawyer. If you don't have those 2 things in place, it won't work. They both have to be in place. One thing you've probably noticed about these cases is they're mostly black heterosexual men. I have a case here, Jennifer Hurlbert, a woman, Lene Halstad in Norway, a woman, but they're much less common than the men. And remarkably, there's relatively few gay men. And I believe that's because judges believe that all gay men are infected. So if you're a gay man and you have sex, you should just assume your partner's HIV positive. I believe that's the prejudice. So it's kind of reverse prejudice, which works against heterosexual men due to this kind of irony. I'm very interested in the issue of the phylogenetic analysis, which is these trees that are found in almost all of these cases. And I think there are great weaknesses to phylogenetic analysis. And it actually, ironically, when I did a thesis in biology back in the 70s, my thesis involved phylogenetic analysis, which back then was a very, very new field. So I think I can understand the deadly flaws in phylogenetic analysis, and I can understand why it always works for the prosecution. And I can explain that at more length. One of these days I want to write a paper on that issue. Another point to recognize is that the use of condoms is not really protection. Even if you do use them, it's not really protection, but it's his word against hers. And obviously, she's going to say no, otherwise she wouldn't have complained. And he's going to say, I used them, and they're going to believe her. Or if it's a woman and a man, well, I guess in a woman's case it would be different. But in the case of a man who's accused of endangering the life of a woman, the man will never be believed. So even if a man uses condoms, it's not really protection unless your partner has publicly stated that they know that you're HIV positive and they're okay with that. The analogy to a deadly weapon, I think, is a big weakness. Like, I have a trouble wrapping my head around how you can conceive something that's an innate part of your body as a deadly weapon, something that you have no control over, even if it existed. Another point is that these cases only occur with HIV. There are supposedly many other deadly viruses, and yet they never end up in court. Why is it? What is the psychology that allows HIV to end up in court and not any other virus? I'd now like to move on to a couple of other cases that are also in adults but were non-sexual cases. One that received a lot of press was a man named Brian Stewart in Columbia, Illinois, who was a phlebotomist, somebody who lets blood. And he was accused of capturing HIV-positive blood from somebody and deliberately injecting it into his son. Of course, there was absolutely no evidence except that he'd been alone in the room with his son, which, are there any fathers who've been alone in the room with their son before? Suspicious behavior. And so he was sentenced to many years in jail, and I recently, somebody I know was in touch with him, and he also was sentenced to many years and is still in jail. One of the most absurd and bizarre cases recently was of Willie Campbell in Dallas. Willie Campbell was a drunk and a drifter and HIV positive, and he spat on a policeman, and that's assault with a deadly weapon, and he got 35 years in jail. Yeah. So these cases boggle my mind. It's like if you have the flu and spit on a police officer, you're going to get 35 years? You might get a misdemeanor, you know, if you spent a month in jail, you'd be unlucky. So it's just incredible. The special nature of HIV allows these massive human rights violations to occur. But now we get onto the difficult part, for me, which is the cases of the mothers. And I'll just briefly introduce you to some of these cases. There are many, and I'm sure in all of these situations there are cases that I know nothing about or just don't know enough about to talk about. The Valerie Emerson case, we'll start on a positive note. This was around 1998. Valerie was positive. Her daughter Tia and her son Nick were also positive. They were all on the drugs, all on AZT. Tia died of, quote, AIDS, and Valerie took herself off the drugs. Her health improved. She took her son Nick off the drugs. The state intervened. They said, you cannot do this. They took her to court, and a judge said, basically, she's lost one daughter already. It's enough. So she won that case, which is actually quite unusual. Sadly, Nick died of cancer about a decade later. That was about 2007. Another case that some people here know quite a bit about was the Tyson case, Kathleen and David Tyson in 1999 in Oregon. Kathleen Tyson was HIV positive, an extremely healthy woman. Her husband, they'd been together for 10 years, claimed to have a monogamous relationship, and he's negative. Are you surprised? I'm sure you're not, but you'd think people would be surprised. So they were taken to court, and they lost medical custody of their baby Felix. What that meant was that she couldn't breastfeed, and they had to give AZT to the baby. Now, they maintained physical custody, so what they did at home, who knows? I've never asked them that question. They're still around in Oregon, and you know they're really enthusiastic dissidents. But I think they've decided they need to protect their son, because until he's 18, he's still endangered. Sophie Broussard was a really awful case too. A Montreal woman who was HIV positive had 2 sons. One got bronchitis, the other was perfectly healthy. The doctors, of course, said PCP pneumonia and said both the children needed to go on the drugs. Sophie resisted. Sophie had that, I don't want to stereotype, but she had that Gallic personality, excitable, and she'd get angry very easily and defensive, and you know, if she didn't like something, she would let you know right away. And that didn't work very well. You can just imagine dealing with Child Protective Services with somebody crying and screaming and telling you you're killing my children. It's like that's what you feel, but you cannot let those emotions out. So Sophie Broussard lost the children despite the efforts of some dissidents. She then kidnapped her own children, flew to Africa. She was unable to maintain a life in Africa, you know, as a single mother with 2 children. And so she had to come back to Canada, at which point the children were taken away from her again. And it wasn't long after that Sophie Broussard died, and I believe it was related, you know, a broken heart, basically. One of the ironies of that case was that the father who got custody, the grandfather of the children, had 2 daughters. Sophie Broussard was the black sheep. She'd never been married, had relationships with several men, very intelligent woman, but the other daughter was the perfect daughter. She'd got a PhD, she'd got married, and guess where she worked? She worked for Amgen as a pharmacist in California. And so when Dad said to his perfect child, should Sophie take the drugs? What do you think she said? So that, again, didn't help. I guess that's a third component. It's not just the accused person and the lawyer, it's the family. If you have a supportive family, it makes a huge difference. How am I doing? Okay, 5 minutes. Okay, so the issues that I have found with these cases basically relate around the use of drugs as the major case. The mother will be coerced. The baby will be forced to take drugs. Breastfeeding is totally forbidden in North America. In the third world, there is a recognition that the emphasis on formula has killed possibly millions of babies around the world. So there's in the third world, mothers are allowed to breastfeed. Mothers will also be under pressure to have a C-section instead of a natural birth, and to even undergo the process called vaginal cleansing, which is a horrible notion, which involves, you know, basically disinfectants to kill the HIV in the vaginal canal. So these are the humiliations and the tragedies that women have to undergo. So in the last section, I'd like to talk about the issue of fighting back. We heard about the Audrey Serrano case in the movie yesterday, in 2007. And we were lucky enough to have in the audience right now Christos Parisis, a lawyer from Athens who is Maria Papagiannidou's lawyer. So I've asked him to talk for a couple minutes.
We want to excuse me first, my bad English. I am not English speaking. We want to greet your conference to wish a successful result. First, we come from our country, in former times, made a region of the Roman Empire under the name of the Achaia. That is to say, the actual Greece. The concept of empire comes from the imperium, the Roman imperium notion, with 3 exceptions. So, my professor of Latin history in Sorbonne said that I don't say that. First, social and ideological structure. Second, the power of the superior Roman magistrates and also of the Roman emperors, the imperatores. Third, the territory occupied by the Roman Empire. Here we speak about the first in social and ideological structure. May because maybe because the custom makes law, and as is told in some cases, the ruling class of Greece, since 1945, decided that the country should be a part of the new American empire, and the Pax Romana is substituted by the Pax Americana, because the Roman proconsul was the governor of the Greece. The new governor of the Greece is named not proconsul but ambassador. The pupils in Greece know that. Thus, the Ministry of Health depends from the orders and decisions of the Ministry of Health of the United States. And the decisions of the Ministry of Health of the United States are automatically constitute the law for the Greek Minister of Health. So, the goes on the thing in the case of AIDS. Is a curious thing that in the Greek laws they are only few things about the AIDS cure, etc. All are decisions of the ministers. Second, a little for the scientific issue. 130 years ago, the writer of the book Das Kapital was writing in the afterword of the second German edition of his work. I quote, this is in the social sciences. In France and in England, the bourgeoisie had conquered political power. Thenceforth, excuse me for the pronunciation, the class struggle practically as well as theoretically took on more and more outspoken and threatening forms. It sounded the knell or knell of scientific bourgeois economy. It was thenceforth no longer a question whether this or that theorem was true, but whether it was useful to capital or not, or harmful, expedient or inexpedient, politically dangerous for the police or not. In place of disinterested inquiries, there were heard prize fighters, paid fighters. In place of genuine scientific research, the bad conscience and the evil intent of apologetic. This thing, I think that if Marx was alive, he wouldn't believe that such a thing, who he was described for the social science of his times, would be actually take place in the exact or positive or nature sciences. Aristotle, I think Aristoteles write some part that επιστήμη χωριζομένη αρετής, Greek, πανοργία καλείται, επικαλείται. C'est-à-dire, science separated from the virtue is called rouge. Rouge.
Yeah, sure.
We hope that in future, mainly the sociologists, historians, and politologists will have the task to clarify the issue of the AIDS, because the issue of the AIDS is not a scientific issue, is the garbage of the science. In Greece, we told that each house has his toilet. The toilet of the biology and chemistry science is Mr. Gallo and his colleagues. Conclusion. There is a moment in the life of the people, such as in the life of the individuals, in which somebody must stare at the truth or surpass her. In our case, we know the truth. The truth is with our part. Remains to take the decision to make her shine or to hide her under egoistical adversions and personal misunderstandings. Marx was writing somewhere that they wanted to kill my book by silence. Thus, from kill by silence, we passed kill books by silence, we passed to kill people in silence. We hope that they will not have this silence, and we saw that in this conference. Thank you.
Thank you so much. I'm going to end just right now.
Yes, and then to the little bit of questions, because
Okay.
they're very important.
Yes. Okay. So, oops. Some of I just want to end by mentioning some of the other cases. You probably remember Kim Bannon's consumer protection case, and that the case should not be forgotten, even though it did not work. It may be useful in the future. And also, of course, we heard about Celia Farber's libel case. So now I'd like to take some questions, and just before I do that, I'd like to let you know that because of my computer problems, I couldn't put this information together, and people probably want to know the names and dates and some of the issues. So I will put a presentation together when I have a computer again, and I will make sure it's on the website with all the other presentations. So if you're worried about getting the dates and names and things, you will get those later.